Hello everyone, this is Advocate Mrinal Dattatray Bua, practicing before the Supreme Court of India and visiting faculty for the cyber laws at ILI. Students, today we are going to discuss the module on search and seizure in cyberspace. We can take the overview of the module. Firstly, I will introduce you with the topic. Then, first chapter will talk about search and seizure of digital evidence. Second chapter deals with safety measures at the exploration spot. Third chapter deals with stages for search, whereas fourth chapter deals with American law and the Fourth Amendment protection against unreasonable search and seizure, whereas fifth chapter provides for the search and seizure in India. Sixth chapter provides for the European Convention on Cybercrime on search and seizure. Seventhly, conclusion and findings, and lastly, we will discuss the summary for this module. Now, what will be the learning outcome? By the end of this module, you would be able to understand concept of search and seizure of digital evidence, safety measures to be taken at the spot of search and seizure, stages for the search, American law and its relevance concerning unreasonable search and seizure, Indian law relating to search and seizure, regional and or international guidelines relating to search and seizure, and conclusions and findings thereon. Now, the introduction. The progress of information and communication technology has transformed the manner in which the people do day-to-day trades and interrelate with the world all over the place. These connections and communications are recognized and stored on a regular basis, accessibly by the people, and business firms over and done with facility was used. Illustratively, the universal smartphone, overhead, and more than a communication device is an instrument which can preserve a whole note of the communications, record, picture, videos and papers, and gathering of other several spatial contents such as application records, which comprises of place tracing or commercial records of the consumer. As computers and telephones progressively sanction us to possess massive amounts of peculiar material available at the touch of switch or display. The growing dependence of computers as information silos also exponentially grows the troubles to related with the damage of regulate over such instruments and the data they cover. This susceptibility is particularly instinctual in the background of law implementation and usage of forced national control to uphold safety, contrasted with persons' right to protect their confidentiality. The right to conduct a search and seizure of persons or places is an essential part of investigation and the criminal justice system. The societal interest in maintaining security is an overwhelming consideration which gives the state a restricted mandate to do all the things necessary to keep law and order, which includes acquiring all the possible information for investigation of criminal activities, a restriction which is based on recognizing the perils of the state-endorsed coercion and its implications on individual liberty. Digitally stored information, which is increasingly become a major site of investigative information, is thus essential in modern day investigation techniques. Further, specific crimes which have emerged out of the changing scenario, namely crimes related to the internet, require investigation almost exclusively at the level of digital evidence. The role of courts and policymakers then is to balance the state's mandate to procure information with the citizens' right to protect it. Now, what is the objective and the scope of this module? Students, the objective and scope of this module is to understand and to study the concept of law relating to search and seizure in virtual space. Now, the first chapter, which talks about the search and seizure of digital evidence. In the conservative surroundings, substances are put in a storage in a physical form that can be put in a storage materially like data printed on papers, bills, receipts, reports, manuscripts, etc., which are vulnerable to harm by corporal approaches such as stealing, robbery, etc. However, in the technology era of microelectronic environs, record is put in storage in incorporeal arrangement creation in a cybernetic sphere where these restrictions of conservative procedures no longer spread on. Therefore, lawbreakers pursuing data put in storage in system with dial-in access can have right of entry to that data from almost wherever in the world. The amount of data that can be lifted or quantity of harm that can be produced by malicious software development encryption may be restricted only by the rapidity of the network and the offender's apparatus. Next point is about advanced planning for search. When the investigating officer is essentially to do a quest in a place anywhere, it is alleged that computer networks or any additional electronic memory devices are likely to be found. It is prudent to call computer forensic expert to along with the examination group. If it is not probable, data may be put together with about the category, kind, model, operating system, web structural design, web structural design, category and place of record storing, distant entry risks, etc., which can be handed on to the forensic expert, for instance, that would aid creating essential groundwork to gather and reserve a proof. There can be some circumstances in which it might not be likely to eliminate the system tangibly, and records might have to be derivative at the place of offense or scene of the examination. The investigator or expert needs to possess required mass media, software and other specific objects, so also exceptional packing things which can preclude harm of records, as the information of magnetic media can be damaged by dirt, lurches and electrostatic surroundings. Now the next chapter deals with the safety measures at the exploration spot. The first point includes taking control of the location. It is very significant to safeguard the one which is doubtful or susceptible or suspect is not permissible to trace any portion of the system or additionally devoted to it, whichever by corporeal ways or by means of wireless device. Meanwhile, computers could be associated over and done with corporeal systems such as fiber optic, cable, telephones or Wi-Fi max wireless networks, or even by the means of cell phones consuming a wireless message port. The investigator has to be awfully aware and may find control from an expert. If not accessible on a place, on cell phone, and proceed stages as per advices. The investigator needs to think of that even by using a switch or by providing a direction by means of a wireless mouse or keyboard, or even by giving a direction using an email message. The whole records either could be smeared out or despoiled, doing it unusable for the investigator. This is also appropriate in the situation of minor instruments or detachable storing device, which have the dimensions of storing enormous quantity of records. Therefore, it is very much significant that persons existent at the place of the examination are parted from the computers, and all devices are reserved out of their influence, as it is not difficult to damage or abolish e-evidence or virtual evidence, and same can be completed from corner to corner away, which could be corporeal or wireless. The investigator must proceed all stages to protect the information. Next point is about the network computers. One should not cut off server connections from the computer if web linkage or processors are involved. Pulling a computer from a network may lose the network and creates damage to the firm's actions. It is usually not applied to confiscate a computer. It needs detaching all the computers which are connected to it. Hardware confiscation with a system on a network can be actually complex, and one should certainly enlist the help of the computer forensic expert in these cases. Now, the planning for the search. The examiner or investigator should follow the various items with him which will facilitate the search, such as disks or cartridges. This can be used to stock duplicates of files from the computer for use in his investigation. Labels, to mark or label cables where they plug in, disks, the various parts of the computer, and to write or protect disks. Next, screwdrivers and other tools to dismantle the hardware for seizure. Glows. One should remember that often latent prints can be taken from the disks or other storage media or hardware. Next, packing materials. It includes rubber bands, tape, boxes, bubble wrap, and if he does not have access to anti-static wrap, paper bags should be used because they have less static charge than plastic bags. Next, camera equipment. It includes videotape and photograph the scene. Next, chain of the custody report sheets and other paper to inventories seized evidence. Next chapter is about stages for the search. First stage is, of course, reliance on the technical expert. One should be cautious and should not do or cause harm throughout a search, as automatically stored data can be simply misplaced. The services of the computer forensic expert shall be taken at every probable place. The specialists can not only assess throughout an examination, but could also contribute in interrogating the firm's technical personnel, because they will know what interrogations to questions to bring about relevant information for the investigation. On site, the investigator has to assess the apparatus and take preventive steps as referred above. Next, he will need to document the way the system is connected together and to take different steps such as marking and photoing the arrangement, labeling all the parts, powering the system down, seizing the documentation of the seized material. Next chapter is about the handling of evidence and computer hardware. First point talks about the protecting the data. The I/O must also safeguard the disks or cartridges he discovers at the place of search with reference to keep the data safely. Most compact disks and cartridges have a little slithering tab that precludes altering the disk information when fixed properly. Inserting a blank disk in the hard drive of the system will retain them from booting up from the hard drive if they are inadvertently switched on. Next point talks about the packaging for the transport. Once the I/O or the experts has dismantled the computer, it is ready to be packed for the transportation to the forensic library. Computers parts being sensitive are easily damaged, and hard drives that regularly collect the records have subtle machineries, so they should be controlled prudently. One should not cover the system components using styrofoam, because small constituent parts can disruption of and become inside the system, producing it to the failure. Next point talks about the to keep system components together. One should keep the constituents of system together. This small structural step can protect a lot of period once the examiners are trying to rebuild the system. Next point, that is single machine or single seizing agent, provides for, if one individual handles the confiscation of a system, the same one can validate the proof at a trial. This simple concern can sidestep misperception, the latter. Next point provides how to transport and store the system. One should not place the system in the trunk of the police vehicle. The system should be protected in such a fashion which would lessen vibrations which may jiggle apart unfastened. The IO should keep the system safely and away and at the dry place which is away from the electromagnetic devices.